So hello everyone, welcome back to Bajirao IAS Academy, UPSC Mains 2024 General Studies Paper 2 Analysis. And in this session, we have some questions which are asked by UPSC in General Studies Paper 2 in 2024 Mains examination. So one by one, we'll try to discuss all these questions which are asked, and we also try to have a proper structure for these questions, and we'll have a detailed discussion of all these questions, right? So the first question that we are going to start this session is with the center-state relations or the federal structure of the Indian Constitution. So in fact, we all knew that India is a federation, and very often India is known as a quasi-federal, right? So quasi-federal in the sense that India is not a federal state in true sense, because in India, in federalism in India, the powers are more leaned or tilted towards the center, and because that particular reason, India is known as the quasi-federal state. However, this is provided by the Indian Constitution, keeping in mind the unity and integrity of the entire nation in mind, right? So in fact, when it comes to Indian federation or federalism in India, so we are having the holding together model, right? So not coming together model, rather we are having holding together model. So in this context, the federalism which is being provided by the Indian Constitution is conducive for maintaining unity and integrity. Now the question is, what changes that Union government recently introduced in the domain of center-state relations? Now center-state relations is a very important topic for your examination, and every year at least one question UPSC asks from center-state relations, and the question is, what changes that the Union government has recently introduced when it comes to the center-state relations? And then you need to suggest some measures to be adopted to build the trust between center and states and for strengthening the federalism, right? So strengthening federalism, cooperative federalism and collaborative federalism is very important when we talk about the essence of federalism in India. However, in recent times, we have been observing that there has been a centralization of powers at the union level. So therefore, it is not feasible for a federal state like India, right? Now we'll have a structure for this question. When it comes to the approach or the structure for this question, first and foremost, as usual, you have to define federalism in the introduction itself, and then you have to address the first part of the question, that is, what are the recent changes that the Union government has introduced in the domain of center-state relations. And in the next part of the question, you need to write a detailed suggestions to build trust between the center and states for strengthening federalism, and ultimately you need to conclude the answer by stressing on the importance of good center-state relations. Now, what are the importance, or what is the significance of center-state relations? And that's how you need to conclude the answer. Now, in the conclusion itself, you can write the recommendations of the Sarkaria Commission, Punchi Commission, Rajmannar Commission, National Commission for Working of the Indian Constitution, and Second Administrative Reforms Commission. So to make your answer more and more impressive and impactful, right? So you can when it comes to the center-state relations or the federal features of the Indian Constitution, you can write the recommendations of all these different committees. So we'll start this question with a definition on federalism. We all knew about the federalism, right? So I hope you have a basic understanding and basic knowledge about the federalism. And in fact, federalism is a form of government or a system of government. For example, US a federal state, Canada is a federal state, India is a federal state. So it is a system of government, and in fact, in that particular system of government, power is shared or distributed between the central authority and various constituent units, and we have the central government, and constituent units are respective state governments. So therefore, in a federalism, or which is a system of government in which power is shared or distributed between the central authority and various constituted units. And in fact, when we talk about the federal system, each level of government has some autonomy and the power to make laws, right? For example, within Indian constitution we have the seventh schedule. I hope everyone have some basic understanding about the seventh schedule of the Indian constitution. Now seventh schedule of the Indian constitution talks about three important lists. So they are state list, concurrent list, and also the union list. And in fact union parliament has the power to make laws on subjects which are mentioned in the union list and concurrent list. And in fact the state legislative assembly have the power to make laws in the subjects from the state list and even the concurrent list as well. So therefore there is a clear distribution of powers between the central authority as well as the state governments as well. So in fact in India state governments also enjoy a certain degree of autonomy, and they also have the power to make laws in their respective domains as well. So this is how you need to define federalism very briefly, and then you have to address what are the changes which are recently introduced by the union government in the domain of center-state relations. First, very important, that is the goods and services tax. And in fact the goods and services tax regime has transformed the tax collection, tax distribution mechanism between the center and states. And in fact a lot of states are dissatisfied with the way goods and services tax is being implemented. And in fact the central government has also not been providing GST compensation to certain states which have been losing revenue because of the implementation of the goods and services tax. And in fact there are a lot of states which are clearly dissatisfied with the how GST has been impacting the financial autonomy of those respective states and the revenue generation capabilities as well. So this is the major issue between center and states. And in fact the 15th Finance Commission and the 16th Finance Commission and the terms of reference of the center for the devolution of funds and finances to the respective states. And in fact earlier 1971 population census was considered for the devolution of finances, but recently center has decided to consider 2011 population census for the devolution of funds and finances. However, most of the southern states are not ready to accept the terms of reference, or not ready to accept the criteria of 2011 population census as a criteria for the devolution of funds and finances, because a lot of southern states, Kerala, Tamil Nadu, Maharashtra, Karnataka, Andhra Pradesh, Telangana, so they have achieved a substantial improvements in terms of limiting the population growth. However, it is not the case with most of the northern states. So when the population of 2011 is taken into consideration, most of these southern states have achieved the population stability, and they have also limited their population growth as well. So by 2011 population census, most of the southern states would get a lower financial devolution as per the 15th or 16th Finance Commission, because remember that more population means more funds, more finances from the center as per the terms of reference given by the center to the 15th and 16th Finance Commission. So this is also a bone of contention between center and state governments. And recently center mulling over the idea of one nation and one election, one nation and one election. So this would be another area of bone of contention, could be between the center and respective state governments. Rather, still it is in the discussion phase, still it is in the deliberation phase, still it requires the consensus between various stakeholders. So therefore this could be a bone of contention as well. And in fact recently center has also introduced some changes in the policies regarding the deputation and transfer of IAS, IPS and Indian Forest Service officers, and these officers are known as the All India Services officers. And so therefore the center has changed policies regarding the deputation and transfer of IAS, IPS and Indian Forest Service officers. And in fact center has granted itself increased control, potentially undermining the state's administrative autonomy and in fact state's control over these All India services as well. And in fact the center replaced Niti Aayog replaced Planning Commission by Niti Aayog, and in fact Niti Aayog is considered as successor to the Planning Commission, the erstwhile Planning Commission, so which have the powers to devolve or allocate finances to different states. But on the other hand, Niti Aayog is just a think tank, and Niti Aayog don't have the powers to allocate finances to the respective state governments. So therefore Niti Aayog has redefined the policy and planning coordination, and Niti Aayog in recent times has been emphasizing on more collaborative approach, but it also altering the traditional center state dynamics as well, right? So apart from that, the controversial formulas that the union government recently framed in the form of ordinances. Remember, agriculture is a state subject in the 7th schedule of the Indian constitution, but despite agriculture being the state subject, the union government has framed the farm laws, and that became the bone of contention between the center and state governments, right? So because of this particular reason, the farm laws became more and more controversial, and these farm laws were later repealed by the union government. And in fact, the union government bringing up these farm laws was seen as infringement upon the state's domain, particularly in the area of agriculture, and it has also sparked a large-scale protests and rising questions about the center-state coordination as well, right? So these are the certain areas of center-state, relations being, or recent changes that the union government has been introduced, and that has resulted in the controversies, or that has resulted in a bone of contention between center and respective state governments, right? So apart from that, there are a lot of other issues also. For example, the office of the governor and misuse of article 365 or 356, right? So president's rule. So all these are certain issues that have been impacting the center state relations, and that also affecting the collaborative federalism and even the cooperative federalism as well. Now in this backdrop, there are certain suggestions could be framed to build the trust between center and states for strengthening federalism as well. Remember, as I have already told you, when it comes to strengthening relations between the center and state governments, you could write, or you could give the Sarkaria Commission recommendations, Punchi Commission recommendations, and Rajmanar Commission recommendations, and National Commission to review working of the constitution, and even second administrative reforms commission. What you have to do, so you maintain a short notes, and in that short notes take the note of the recommendations of the National Commission for Working of the Constitution, Second Administrative Reforms Commission, and Punchi Commission, and even Sarkaria Commission and Rajmanar Commission. So all these Sarkaria Commission and all these commissions and its recommendations are very, very important. Now in this context, there are certain recommendations for improving center state relations. So there is a need for collaborative dialogue, and that ensures cooperative and collaborative federalism in India. And in fact, we need to foster open and transparent communication between the center and states, and there is also a need for regular meetings and discussions. Now how meetings and discussions at regular intervals could take place? So this could take place through the zonal councils, right? So we all have the idea about these zonal councils, and apart from zonal council, the interstate councils, both interstate councils and zonal councils would ensure regular meetings and discussions between the union government and the state government, and they can also find a common ground on the issues which have been affecting both center and state relations as well. Now in this context, zonal councils and interstate councils have a very crucial role to play, and in fact there is also a need to empower states in different areas. Now when it comes to the total financial expenditure on one individual, the state governments have been spending more compared to the central government. So in this context, there is a need to give more and more powers, financial powers and other sort of powers to the state governments. So union government should devolve more decision making powers along with the resources to the state governments, and at the same time there is also a need to ensure accountability and transparency, and this could empower the states to take charge for the development agenda with solely relying on the center, right? So without depending on the center, the state government themselves can govern or administer in their respective domain effectively. And apart from that, there is also a need for a clarity in roles between the union and state governments. So therefore there is a need for clear roles and responsibilities between for both center and state governments at both levels of the government, and that would reduces overlapping of the jurisdiction as well as the conflicts between the center and states as well. So this clarity can streamline the operations, and it could also prevent the policy duplications as well, right? So as of now, the problem is that center has been encroaching upon the powers and the responsibilities of the state government, and state governments have been encroaching upon the certain areas of the central government's powers and responsibilities. So therefore there is a need to clearly define the powers and the responsibilities of these different levels of the government. And apart from that, there is also need to build trust and confidence, so that is also very important for strong center state relations or friendly center state relations. So we need to foster a culture of trust and cooperation through mutual respect and understanding, and apart from that, establishing trust can also facilitate smoother implementation of the policies and reforms as well. Now in this context, you have to write a conclusion as well. Remember, as I have already told you, when you write any answer in center state relations, you have to mention the Second Administrative Reforms Commission recommendations on better center state relations, Rajamanar Commission recommendations, Sarkaria Commission recommendations, Punchi Commission recommendations, along with the Venkatachalaya Commission recommendations as well, right? So conclusion is that a harmonious relationship between center and states within a federal system like India is very important for conducive economic environment. So it is not just for the conducive economic environment, it is very important for the policy stability, economic development, economic growth, and achieving the goals and aspirations, particularly the sustainable development goals. So everything, it is very, very important that the harmonious and friendly relations between both center and the state governments. So collaboration, empowerment, clarity, and trust building are essential components, or very important components, for fostering cooperative and productive relationship between center and state governments. And that's how you need to write an impactful conclusion, and you can conclude this answer. So remember that in this particular answer you could mention a lot of data of the articles and a lot of organizations, both statutory organization, constitutional organization, and extra constitutional organizations, and you could also mention examples along with these points, so that it further enriches your answer, further makes this particular answer more and more effective. So that's how you need to write this particular answer. So next very important question, which is asked by UPSC, and it is also a very, very important, and in fact UPSC has asked this particular question from Indian polity and constitution part, Indian polity and constitution part, and within Indian constitution and polity, so there is another part which is judiciary. Okay, so from judiciary UPSC has asked this question, and public interest litigation is also very important. And in fact, if you are regularly reading newspaper, you very often come across this public interest litigation is filed on that particular issue or this particular issue. So therefore public interest litigation is very, very important, and this question is primarily about this public interest litigation. The question is, explain the reasons for the growth of public interest litigation in India, and as a result of it, Indian Supreme Court has emerged as world's most powerful judiciary or world's most powerful court. Now this question has two important components or two important parts. In the first part of the answer, what you have to do, you need to mention the reasons for the growth of public interest litigation. Now why there is a need of public interest litigation, or why there is a sudden increase in the public interest litigations into the Indian judiciary, despite there are different organs of the government such as judiciary, executive, legislature, right? So why there is a sudden increase in the public interest litigations now, why people have been increasingly approaching the judiciary instead of executive or the legislature to resolve their grievances. And second part of the question, because of increased number of public interest litigations, Indian Supreme Court has emerged as world's most powerful court. Now I'll tell you one example, which is Article 142 of the Indian Constitution. That is, the Supreme Court is empowered to provide complete relief on any issue, right? So Supreme Court very often using Article 142. So 142 deals with the power of the Supreme Court to do a complete justice in any matter, right? So therefore all these factors have made Indian Supreme Court one of the world's most powerful judiciary. Now what is the approach of this question? So this question has an approach. Now as usual, in the introduction itself, you have to define what constitutes public interest litigation, or what is public interest litigation, and then you need to discuss reasons for the growth of public interest litigations in India. Now, what are the reasons because of which the public interest litigations have increased, and then in the second part of the answer, you need to discuss how Indian Supreme Court has emerged as the world's most powerful judiciary due to this public interest litigation, and ultimately you need to write a conclusion about the separation of powers. Separation of powers is also very important, and you could also mention the proactive judiciary with the judicial activism, but not judicial overreach, right? So there is a difference between judicial activism and judicial overreach. So I hope judicial activism and judicial overreach. So I hope you have overreach and you have some basic understanding about both judicial activism and judicial overreach as well. So judicial activism is not considered as the violation of the principle of separation of powers, which are implicitly mentioned in the Indian Constitution. But on the other hand, judicial overreach is considered as the violation of the principle of separation of powers. So because when we talk about the judicial activism, so within judicial activism, so Supreme Court has come up with a lot of progressive judgments, particularly the Vishaka guidelines that the Supreme Court has given in the year 1997 in the area of protection, prevention of sexual harassment of women at workplaces. So that is an example of the judicial activism, and in fact drought relief is also part of the judicial activism of the Supreme Court, right? So but on the other hand, judicial overreach is the encroachment on the responsibilities and roles of other branches of the government. So therefore it is a clear violation of the separation of powers principle of the Indian Constitution. Now as I have already told you that in the introduction itself, you need to briefly define the public interest litigation. So as I have already told you that the public interest litigation, what is public interest litigation? Public interest litigation means litigation which is filed in a court of law for the protection of the public interest, right? So for example, a larger community or larger public have been facing the risk. It is not just about the public, it is about the environment, and it is about the particular religion, particular terrorism, pollution. So all these factors, and any individual can file a public interest litigation. So public interest litigation means litigation which is filed in a court of law for the protection of public interest, particularly in the areas of pollution, terrorism, road safety, and even the constructional hazards, etc. So any matter where the interest of the public at large is affected, and that can be addressed by filing the public interest litigation in the court of law, right? For example, if you as a responsible citizen, you believe that the interest of the public at large is affected by a certain act, so you can file a public interest litigation in the court of law, and you can also seek relief that since the public interest at large is involved or affected by the particular act, such as road safety, constructional hazards, terrorism and pollution. So public interest litigation is a key tool for ensuring justice for all and also protecting the rights of the underprivileged sections of the Indian society as well. Now, what are the reasons for the growth of public interest litigation in India? There are certain reasons for the growth of public interest litigation. So when we talk about the reasons for the growth of public interest litigation, in recent times judiciary has become more and more proactive, and we all knew about that. Now, why judiciary has become more and more proactive? It is because of the executive and legislature are unable to perform their constitutional roles and responsibilities in a proper manner, and because of that particular reason, people have been increasingly approaching the judiciary to resolve their grievances through the public interest litigation. So all these factors have made the Supreme Court or the judiciary to become more and more proactive, and that is known as the judicial activism, right? So this is known as judicial activism. And in fact, through the public interest litigations and Supreme Court, through its methods of judicial activism, addressing the social justice issues, and it has been protecting the fundamental rights as well. Remember, fundamental rights are provided in the Indian Constitution, Part 3 of the Indian Constitution, and fundamental rights are civil liberties which are provided by the Constitution to the citizens against the arbitrary action or interference of the state in these fundamental rights. And in fact, in recent times, filing a public interest litigation has become a very easy, and in fact, you should not necessarily be a lawyer or an advocate to file the public interest litigation. So any responsible citizen can file a public interest litigation in the judiciary. So therefore, it has made it easier for the marginalized groups to seek justice regardless of their financial status. Remember that the directive principles of state policy, particularly Article 39A, talks about what? Equal justice and free legal aid. Equal justice and a free legal aid. So this has been included in the Indian Constitution through the 42nd Constitutional Amendment Act. So all these factors have made that these marginalized groups can file a public interest litigation much more easily than before, and they can seek justice regardless of their financial status. And in fact, the public interest litigation has addressed issues. It has previously addressed a lot of issues related to the environmental degradation that has been taking place across different parts of the country, and human rights violations, particularly in the areas where the Armed Forces Special Powers Act has been enforced, and even corruption related matters, and even drought relief and disaster relief, and even Bhopal gas tragedy, Bhopal gas tragedy victims. So Supreme Court has granted relief to most of these issues through the public interest litigation. But one thing that we need to remember here is that public interest litigation has got a lot of popularity, and in fact the awareness about the public interest litigation has increased enormously in recent times. So that is because of the media, right? So we have a different form of media, and media coverage to the public interest litigation has increased awareness among the people about the public interest litigations. So overall, media has played a very important role, and in fact in recent times we could also clearly observe the executive and as well as the legislative inaction as well in different areas because of the lack of executive and legislative inaction. So what people are doing, people are filing public interest litigations in the judiciary or in the Supreme Court, and they are seeking relief, and they are also they also wanted that the court order the executive or the legislature, particularly the executive, to provide relief in certain areas. So therefore there has been a growing inaction on the part of the executive and legislature, and that is being viewed as the inefficient nature of both executive and legislative branches. And if I can mention one example in this arena is the Vishaka guidelines announced by the Supreme Court 1997, which is prevention of sexual harassment of women at workplaces. So after this Vishaka guidelines, and in the year 2013, this act prevention of sexual harassment of women at workplace, the POSH Act was passed in the year 2013 by the Indian Parliament after the Supreme Court announced Vishaka guidelines. And in fact, in recent times, a lot of non-governmental organizations and legal aid organizations, so they have also played a very important role in initiating the public interest litigations. For example, so there are a lot of legal aid organizations and non-governmental organizations. For example, Social Cause is a non-governmental organization, and Association for Democratic Reforms is also an organization or legal aid organization. So all these organizations have been actively filing the public interest litigations, and they are also seeking relief on certain matters. And in fact, the legal framework has also been evolving, and this legal framework, which has been governing the public interest litigation, has been evolving over a period of time, and it has been making it easier, more and more easier, to file these public interest litigations. So all these factors have increased the public interest litigations in the Indian judiciary, and the increased number of public interest litigations, and particularly because of the executive and the legislative inaction, the Supreme Court has become a powerful court in the world. And in fact, Supreme Court is known as one of the most powerful courts in the world. So we'll discuss about that as well, right? Yes. So how Indian Supreme Court has emerged as the powerful judiciary, so particularly because of the public interest litigations. So in fact, Indian Constitution has provided the judicial review, particularly through Article 32 of the Indian Constitution, and even Article 226 of the Indian Constitution, Article 13 as well, right? So the power of judicial review further strengthened the judiciary, particularly the higher judiciary in India, Supreme Court and high courts, even strike down the constitutional amendment acts and strike down the important legislation. So one example was the 99th Constitutional Amendment Act. So the 99th Constitutional Amendment Act has brought the National Judicial Appointments Commission, and in fact the Supreme Court has declared that the National Judicial Appointments Commission would be unconstitutional because it encroaches or it violates the independence of the judiciary, which is the basic structure of the Indian Constitution. So in fact, Supreme Court has a power to strike down the unconstitutional laws and even executive orders, and not just executive orders, and even the constitutional amendments which are being made by the parliament and the laws which are passed by the parliament. So therefore all these things have made the Indian judiciary or Indian Supreme Court more and more influential and powerful as well. And in fact, there are a lot of landmark rulings, and those landmark rulings have placed a significant checks on the government powers as well. For example, the Indian Supreme Court has been very often using Article 142 of the Indian Constitution. So that is dealing with the complete justice. Supreme Court doing complete justice in certain cases, right? So that is Article 142 of the Indian Constitution. Now, apart from doing complete justice, so we also knew about the basic structure doctrine of the Keshwananda Bharati judgment, right? basic structure doctrine. Now why basic structure doctrine is a very important in Keshwananda Bharati judgment? Because it has certain salient features of the Indian constitution, and in fact in Keshwananda Bharati judgment of 1973, Supreme Court has held that the Indian Parliament has the power to any part in the Indian constitution, provided that that amendment should not impact the basic structure of the Indian constitution. And basic structure has been evolving, and Supreme Court has been defining the basic structure time to time. Right. So apart from the judicial activism of the Supreme Court through the public interest litigation has also made Indian judiciary, particularly the Supreme Court, one of the most powerful courts in the world. Right. So there has been an increased number of public interest litigations, and increased number of public interest litigations have empowered the judiciary to address certain issues that go beyond the traditional litigation. Right. So in fact, public interest litigation is very often considered it is beyond the traditional litigation, and in fact very often Supreme Court also grants relief to the affected community, affected individuals and affected entities in the case of the public interest litigation. So public interest litigation allows citizens to approach the court directly for matters of public interest, so thereby broadening the scope of the judicial intervention, and that also provides scope for the judicial activism for the judiciary. However, in recent times, in certain judgments of the Supreme Court have also been leading to the judicial overreach as well. For example, Supreme Court has been giving judgments on the national anthem in cinema halls, and Supreme Court judgment on ban on liquor within the 500 meters of the national highways. So all these things are being seen as the judicial overreach or instances of judicial overreach from the Supreme Court. So however, when we make global comparisons between Indian Supreme Court and the Supreme Courts of other countries, so compared to other judiciaries like the United States, where courts are more restrained in intervening in the policy matters, Indian Supreme Court's proactive approach has been arguably made it one of the most interventionist and most powerful courts globally. So ultimately, you need to write certain things about the importance of the public interest litigation, significance of it. So public interest litigation has been instrumental in bringing about social and political change in India. There is no doubt about that. So it has also helped to strengthen the Indian judiciary and protect the rights of the marginalized communities in India. However, so the growth of the public interest litigations in India have been reflecting the positive trend towards more accountable and transparent society. So however, in this context, one thing that we need to remember, that there has been a executive as well as the legislative inaction on certain policy matters, and that has to be taken very seriously, and that is a one way along with the good governance, and that could reduces the public interest litigations in the judiciary, and also makes it also helps judiciary focuses on the huge pendency of the cases as well. So that's how you can conclude this answer. So next question is about Indian secularism, and this is also a very important question, because remember that secularism is mentioned in the Indian constitution, particularly in the preamble. So secularism as a principle which is only added or included in the Indian constitution through the 42nd Constitutional Amendment Act. However, the original constitution don't have a term called secularism, but secularism is implicitly mentioned in the Indian constitution through various fundamental rights and other provisions of the Indian constitution. Now the question is, discuss India as a secular state and compare with secular principles of the US Constitution. Now when we talk about the gender studies paper 2, now one thing that you need to understand is that every year there is at least one question from the comparisons. So compare the Parliament of India and UK, compare the presidential form of government and parliamentary form of government of India and US or any other country for the sake, and compare the secular principles of India and US. Now every year at least there is a one question, and if you read this topic well, so you can easily score 15 marks or 10 marks, because every year there is one question, and you can also see the previous year questions, and you can observe this kind of a questions UPSC has been repeating regularly. So secularism is a very important principle of the Indian Constitution, and in recent times the secular credentials of India are also increasingly questioned, and in this context this question has been asked. The question is, discuss India as a secular state and compare with the secular principles of US Constitution. So this is a very easy question, so there are no complicated directive words in the answer. Now in the approach, first and foremost what you have to do, you need to clearly define what is secular state, and then discuss the features of India as a secular state and compare the secular principles of India with the US Constitution, and conclude the answer by stressing on the importance of maintaining the secular ethos. So that's how you need to have a proper framework or an approach for this particular question. And when we write this answer for secularism, first and foremost what you need to do, so you need to define secularism. So when it comes to definition of secularism, a secular state means, we'll try to understand the definition of secular state or secularism. Now secularism generally means, secularism is a term which has been originated, which has the Western origin, right? So it has the Western origin. So that essentially means that the complete separation of state and religion. Complete separation of state and religion is the secularism, is Western form of secularism, and this form of secularism is known as a negative form of secularism or negative secularism. But on the other hand, India is not following the positive secularism, right? So India has been following positive secularism, which is different from the negative secularism. India has been following positive secularism. Now what is exactly positive secularism? When we talk about the positive secularism, so in fact it is not a complete separation of state and religion, rather there will be equal distance of state from the religion, equal distance of state from religion. And in fact state also treat all religions equally. State treat all religions equally. So right, so that is equally, and that is positive secularism, and that is the difference between the Indian form of secularism and the Western secularism. I hope it is very clear for you. So Western secularism is complete separation of state and religion, but on the other hand positive secularism or Indian form of secularism is equal distance of the state from all religions, and state treat all religions equally, right? So that is the basic difference. And when it comes to the secularism, as I have already defined, so secularism treat all its citizens equally regardless of religion, and in fact state also claims to avoid preferential treatment for a citizen based on their religious beliefs, affiliations, lack of either, over those with the other profiles, right? So in a very simple terms, state should not discriminate between individuals on the grounds of religion. So that is secularism. Very simple terms, that would be secularism. And in fact Indian Constitution, particularly Article 15 of the Indian Constitution, talks about secularism, or talks about this particular principle, that state should not discriminate between individuals on the ground of religion. So that is mentioned in the Indian Constitution. So that means secularism is implicitly mentioned in the Indian Constitution. Now, in this context, what are the basic features of India as a secular state? So, India as a secular state has a certain secular or basic features. For example, as I've already told you that secularism as a word, as a term, is not originally included in the Indian Constitution. Rather, secularism principle is implicitly covered in the Indian Constitution through right to religion, Article 15 of the Indian Constitution, Article 16, etc. However, the word secular explicitly incorporated into the preamble of our Constitution through the 42nd Constitutional Amendment Act in 1976. So, a secular in the Indian Constitution means that there is no official religion for the state of India, right? For Indian government or for the state of India, there is no official religion. And we all knew that within the fundamental rights, particularly Article 25 to Article 28 of the Indian Constitution deals with the right to religion. So Article 25 of Indian Constitution provides for people with the freedom to profess, practice, propagate any religion, and in fact people are also allowed to practice their religion and carry out religious symbols unless it harms the unity and sovereignty of the country as well. And in fact, there are a lot of state funded institutions, and those state funded institutions cannot ask the students to follow any religion, and which is mentioned in the Article 28 of the Indian Constitution, and that also reflects the secular credentials of the Indian Constitution. And in fact, as I've already told you, that Article 15 of the Indian Constitution prohibits discrimination on the grounds of religion by any other religion, or an individual from any other religion, or person or state itself. So no one should discriminate other individual. Even state should not discriminate individuals based on the grounds of religion, and that is the crux and essence of India's secular ethos or secular principles. And in fact, Dr. B.R. Ambedkar once, in fact, in one of his Constituent Assembly debates, has clearly held that secularism does not mean that state shall not consider the religious sentiments of the people. And in fact, according to Dr. B.R. Ambedkar, a secular state means that government should have the power to impose any particular religion on the remaining people. And that is the only limitation that Indian Constitution has recognized, right? So the state should not have the power to impose one particular religion on the remaining people. For example, imagine that in India, majority of the people are Hindus, right? So state should not impose one particular religion on the remaining people. And according to the Dr. B.R. Ambedkar, and that is the essence of secularism, and that is the only limitation that the Constitution recognizes when it comes to the secularism. And so once you have mentioned this first part of the answer, secularism, Indian secularism, and features of Indian secularism, so then you make a simple comparison between the secular principles of India with the US Constitution. Now US is also part of the West. Now what I have told you with respect to secularism which is followed in the West, now when it comes to the secularism which is followed in the West, so Western secularism is a negative form of secularism. Now what is the negative form of secularism? So negative form of secularism actually means that negative form of secularism means that the complete separation of state and religion in a particular form of in Western secularism, right? So US Constitution's First Amendment itself protects the right to practice religion, but it doesn't explicitly label country as a secular state, right? So the First Constitutional Amendment Act does not necessarily or explicitly label US as a secular state, and in fact India is considered as a secular country with no state religion, and we have no state religion, and we have the state treat all religions equally, and equal distance from all religions is the basic principle involved in the secularism. And in fact, constitution also guarantees equal respect for all religions in article 25 to article 28 of the Indian Constitution. And apart from that, US Constitution's First Amendment Act also protects the right to assemble peacefully when it comes to the matter of religion. And the Constitution of India under article 19 also guarantees the right to assemble peacefully without arms as well, right? So in fact, for the religious gatherings or for any religious purposes, people can peacefully gather and they can preach their religion, they can preach their ideals, beliefs, etc. So therefore, the First Amendment in US and also Article 19 of the Indian Constitution have imposed no restrictions on people who are gathering peacefully for the religious purposes. And in fact, in India, state can intervene in the religious matters. For example, triple talaq. Right, so triple talaq is considered as an issue which is the violation of the basic human rights of women, right? So it is also a matter of dignity for the woman. And apart from that, woman entry into the Sabarimala temple, right? So this would be another area that state has intervened. And in fact, in Hindu temples, Devadasi system is widely prevalent. So Devadasi system is also widely prevalent in Hindu temples. So Devadasi system is attaching young girls to the temples. So therefore, a state can intervene in religious matters, particularly to promote social reform in India. But on the other hand, in US, the First Amendment Act prevents the government from establishing a religion of its own, and also prohibiting the free exercise of the religion as well. But in India, so state can intervene in the religious matters, particularly to promote social reform. So people of India are free to celebrate their festivals equally, and our constitution provides right to follow, practice and promote any religion of people's choice. But at the same time, state can also intervene and protect our fundamental rights if it deems necessary. And in fact, India is home to many religions. India is a diverse country and it is home to many religions, and India is a secular state and model to other nations as well. So therefore, India plays a very secularism helps in spreading unity among different culture, and India is also the largest full-fledged secular democracy in the world as well. And that's how you can conclude this particular answer about Indian secularism. And next, a very important question, citizens charter. Remember, this citizens charter is also very important, and every year there is at least one question from the citizens charter as well. So in this question, we'll understand what exactly is the citizen charter, and what is the significance and importance of the citizen charter, and what are the limitations, shortcomings and drawbacks of the citizen charter, and how to overcome them as well. So the question is, citizen charter has been a landmark initiative in ensuring citizen-centric administration, but it is yet to reach its full potential, and in this context identify the factors hindering the realization of its promise and also suggest measures to overcome them. So I'll try to explain what is a citizens charter, right? So firstly, I'll briefly try to explain what exactly is a citizens charter. Now, citizens charter actually means that it is a list of responsibilities and roles and services that one organization provides to its customers, right? So that is known as a citizen charter. Now, citizen charter is a comprehensive document in which one organization mentions its roles, its responsibilities, its services, and details about the grievance redressal mechanisms. So everything is being mentioned in these citizens charter. So that would lead to the Sevotam model, right? So that would lead to Sevottam in service delivery. So Sevottam in service delivery also means the service excellence, right? So that means service excellence in delivery of services. So in this question, what should be the approach of this question? So first and foremost, you need to define what is citizen charter in the introduction, and then you need to discuss how citizen charter ensure citizen centric administration. And then you need to examine the factors which have been hindering the realization of its potential, and ultimately you need to conclude the answer by suggesting some measures to strengthen the citizen charter. So this should be the the approach of this particular question. So in the introduction, as I have already told you, that you have to define what is a citizen charter. Now citizen charter is a document which represents the systematic efforts. It is a document and it represents a systematic effort to focus on commitment of the organization towards the citizens, right? So what is the commitment of an organization towards the citizens, towards the customers, in respect of the standard of services that the organization provides, and the information about the organization, choice and consultation, non-discrimination and accessibility, grievance redressal, courtesy, and value for money, right? So these are the various aspects that the citizen charter should consist. The citizen charter of one organization should actually consist. Now in the next part of the answer, we will try to understand so how citizen charter ensure citizen-centric administration, right? So in fact, citizen charters play a very important role in providing citizen-centric administration, and how these citizen charter usually do it. So citizen charter clearly defines service standards, and that would further helps citizens know what to expect from the administration. And apart from that, the citizen charter also promotes accountability, and citizen charters very often hold the entire organizations accountable, and they would be more and more transparent towards the citizens and the customers by providing a platform for the grievance redressal. For example, if you have any grievances, so citizen charter have the details that how to redress your grievances, right? So that ensures transparency in the functioning of the organization as well as accountability as well. And in fact, it ensures participatory governance, and it also ensures empowering citizens, or it also empower the citizens as well, because citizen charter inform the citizens about the services which are being provided by an organization to the citizens, and standards of the service, and their rights if services is poor, and grievance redressal mechanisms. And apart from that, these citizen charters can also help organization tune their planning, policy, performance to the needs of the citizens as well. So by doing these things, citizen charter can ensure the citizen-centric administration or citizen-centric governance, and that is very important to achieve service excellence or the Sevottam model of administration. And in fact, citizen charter can also help change the mindset of the public officials from having power over the public to having duty of care to the service providers, right? So now, what are the factors which have been hindering the realization of its potential? There are a number of factors which have been hindering the potential for the realization, right? So hindering the realization of its potential. So when it comes to the citizen charter, I would like to tell you some limitations of this citizen charter. So which has been these limitations have been hindering the potential of the citizen charter, particularly for example citizen charter have no legal backing. So there is no legal backing for the citizen charter. So this is one disadvantage. And secondly, so when we talk about the citizen charter, so citizen charter are very often not they're not published in local languages or vernacular languages. So this would be another major disadvantage with respect to the citizen charter. And lack of awareness among the public, lack of awareness among the public about the citizen charter. So even though citizen charters are being published, there are no grievance redressal mechanisms within these citizen charter. So therefore there are number of issues within the citizen charter. So many citizens, especially in rural areas, are unaware of the citizen charter and the rights of those customers and the citizens that the organization must uphold. And in fact, there's also an absence of robust and independent institutions to monitor and enforce the charter, and that also limits its overall impact as well. And in fact, these charters don't have the legal backing, and they are non-binding in nature, and many agencies are treating these citizen charter as the voluntary guidelines rather than a mandatory framework that every organization should have. And in fact, there is also a strong resistance from the officials who perceive increased transparency and accountability as a threat to their authority. And apart from that, there are no penalties as well for the agencies that fail to adhere to the charter, or incentives for those who implement it well. And even if any organization has been implementing the citizen charter well, so those organizations, even if they are implementing the citizen charter, government or any other agencies are not rewarding such organizations, so there's no incentives. So this would be another major factor. So in this context, there is a need to increase public awareness, need to strengthen legal backing, institutional oversight, capacity building of officials, digitalization of services, and there is also need to provide incentives and penalties for organizations which are not implementing. There is a need for penalties, and organizations which have been implementing the citizens charter, there is a need to incentivize those organizations as well. And citizens charter can evolve into effective tools for ensuring transparent, accountable, and responsive public services if they are implemented in letter and spirit. And this transformation is crucial and very important for realizing the vision of good governance in India by the year 2047. Right, so that's how you can conclude this particular answer on a positive note. And however, all these things have to be implemented on an immediate and on urgent basis, so that citizens charter can be implemented in letter and spirit, and organizations can work in a transparent manner, and they are also accountable to the public as well, and it would also result in empowering public and citizen centric administration as well. So that's all in this lecture, and thank you so much. So if you like our work, so please subscribe our YouTube channel and also hit the like button. Thank you.